So the Lionel Cohen lecture is perhaps the Faculty of Law's most important and prestigious annual lecture. The first such lecture was delivered in 1953. Fun fact of the day, it was actually by an American, Professor Arthur Lehman Goodhart, who was a professor at Cambridge, one of the first non-British masters at Cambridge. And this, in 1953, was close to the graduation of the first class of the law faculty, which is now marking 75 years since its establishment. And ever since, almost consecutively, it has been delivered by a leading jurist from the Commonwealth. The list of Lionel Cohen addresses includes a very impressive collection of lords and barristers, and we're delighted that Lady Rose will be joining this list today. The Lionel Cohen lecture marks the unique relations between the British and the Israeli judiciaries and legal communities in general, while these relations go back to the common law tradition, which is a major basis of the Israeli legal system. In today's complex times, the relations span many other areas of common interest. Lord Lionel Cohen was born in 1888. In 1943, during the Second World War, he was appointed as a judge in the High Court. He then was appointed to the Court of Appeals. And in 1951, he was appointed a law lord, entering the House of Lords, where he served until his retirement in 1961. And Cohen also chaired many royal commissions in the years following the Second World War, particularly in the areas of company law and compensation. The trustee of the Lionel Cohen Lecture Fund is currently Lionel Cohen's grandson, here on the screen with us virtually, Sir Jonathan Cohen, King's Counsel, himself a High Court judge. And the Faculty of Law is extremely grateful for the continued support of the Cohen family, and Sir Jonathan has also graciously agreed to say a few words before Lady Rose's address via Zoom. And I will shortly give him the floor, and it's a pleasure to see you, Jonathan, albeit online. A few words about our distinguished speaker, Lady Rose, by way of introduction. Lady Rose is a Justice of the Supreme Court of the United Kingdom, born to a Jewish family in London, educated in Cambridge and Oxford, and also an alumna of the Hebrew University, it turns out, from the 1970s during her gap year. Lady Rose was called to the bar at Gray's Inn in 1984. Subsequently, she practiced law with an expertise in the complex areas of tax and competition, rising through the judicial ranks until her latest appointment as a Justice of the Supreme Court in 2021. She has also been very active in improving access to justice in Great Britain, and hence the topic of her address today, breathing life into the law, achieving access to justice in the modern state. And I'm so very grateful that Lady Rose has been able to accept our invitation despite these very difficult times, and also to the British Friends of the Hebrew University for facilitating this visit. The lecture will be followed by some time for questions and answers, make it a little bit more interactive, of course. In any case, Sir Jonathan, the virtual floor is yours, and then we will hear the address by Lady Rose. Thank you.
Thank you, Tomer. Good afternoon, everyone in Israel. Good morning from London, where temporarily, at any rate, it's not raining. It's a great pleasure to welcome our audience in Israel and in England, and of course, in particular, our speaker, Lady Rose. As Tomer has mentioned, she had a very distinguished career academically and as a practicing lawyer, and held many posts, which I will not weary you with by reciting them all. But as a Justice of the Supreme Court, the range of cases that she decides is enormously wide and covers all areas of the law of England and Wales, and in some instances, Scotland as well, even including an appeal or two from me sitting in the family division. The demands of the job on her time are enormous, and we are very grateful to her for accepting the invitation and finding the time to prepare and now to deliver this lecture. As the Dean has mentioned, things are, you know better than me, very difficult in Israel at the moment. And so we're especially grateful to Lady Rose for making the journey and adding her name to the list of illustrious Lionel Cohen lecturers. Lady Rose, thank you.
Well, thank you both to Tom Eyre and to Sir Jonathan for those very generous, welcoming words. Fast forward a few thousand years and we have Magna Carta, an early Bill of Rights that has a fair claim to being the most celebrated document in English legal history. Magna Carta is a charter which was sealed on the 15th of June 1215 by the then King of England, King John, recording the terms and conditions he agreed with a group of noble barons in the hope of preventing a civil war. It is true that the document got off to a rocky start, being annulled by the Pope a few years later, but its main provisions were reintroduced by successive monarchs, and there's no doubt that it has gained an iconic status in British legal history. This is exemplified by the fact that the carved stonework over the main entrance to the Supreme Court in London, where I work, includes a scene showing the figures of King John and the barons and the image of one of the 4 remaining original parchments of the Charter itself is etched onto the glass doors leading to our library. Sir Christopher Greenwood, former judge of the International Court of Justice, examined the history of Magna Carta in his own 2015 Lionel Cohen lecture here, and concluded that the primary importance of Magna Carta lies not so much in what it was, but what it has come to symbolize. Its most famous clauses, clauses 39 and 40, remain on the statute book and still ring powerfully today. No free man shall be arrested or imprisoned except by the lawful judgment of his peers or by the law of the land. And, key to my topic this afternoon, to no one will we sell or deny or delay justice or right. Those words have come to represent a commitment to the rule of law and to fair and effective access to the courts. Drafters of more recent Bills of Rights texts have invariably included similar guarantees about the right to bring your claim before an independent and impartial judge. Article 10 of the Universal Declaration of Human Rights entitles us all to a fair and public hearing. The Sixth Amendment of the United States Constitution establishes rights to a speedy and public trial. Particularly important in the UK is Article 6 of the European Convention on Human Rights. This states that individuals are entitled to fair and public hearings in the determination of their civil rights and obligations or of any criminal charge against them. And looking at the case law of the European Court of Human Rights in Strasbourg, which interprets the Convention for the benefit of all the contracting states, Article 6 is the right that the court finds most frequently have been infringed. This afternoon, I'm going to talk about civil rather than criminal access to justice, and I want to examine 3 particular issues which court systems have long been wrestling with. First, how do you ensure that the kinds of claims which are particularly challenging for a justice system to accommodate can be brought and managed and decided efficiently and effectively? I have in mind the very many small claims for injury or financial loss brought by individuals, usually against big corporations or insurers. Second, how can you ensure that cases come before a court or tribunal with the right expertise and experience to help a litigant navigate their way through what may be a complicated area of the law? Thirdly, insofar as access to justice includes access to a lawyer to advise and represent you in court, how have recent changes to the way litigation is funded in the United Kingdom helped or hindered access to justice? First, then, let me describe some recent innovations in the court system in England as to how claims are brought. There has always been a problem with ensuring access to justice in a situation where a large number of people all suffer a relatively minor injury or a small amount of financial loss arising out of one and the same unlawful conduct by one particular potential defendant. Usually the person who allegedly caused that damage is a well-resourced global corporate group, which can be expected to fight the claim as hard as they can. If the justice system can facilitate all those people joining together to bring a single claim with the same lawyers, then they can share the costs. And if the claims can all be dealt with at the same time before one judge, that will help ensure that there is consistency in the law applied and in the value of the compensation awarded. And it might also encourage the defendant to agree to a compromise to settle the claim, giving a quicker result for all the claimants. And it's important to realize that access to justice does not always have to result in a trial in court and a long judgment. The settlement of the claim can be just as effective and cheaper for both parties in the long run. There are various procedural mechanisms by which this can be done. The United Kingdom has not generally introduced the kind of class action that is familiar in the United States. Class actions allow a single person to bring a claim and obtain redress on behalf of the whole class of people who have been affected in a similar way by the particular act of wrongdoing. And that's long been possible in the United States and more recently in Canada and Australia. Whether legislation to establish a class action regime should be enacted in the UK has been much discussed. In 2009, the government rejected a recommendation from the Civil Justice Council to introduce a generic class action regime applicable to all types of claim. Instead, we have an array of 3 distinct procedural mechanisms. The oldest of these in English law is a procedure called a representative action, and that dates back many centuries. It is in effect like a class action, but it's very limited in scope. A representative must satisfy the court that they have the, quote, same interest, close quote, in the claim as their co-claimants. But importantly, it cannot be used in situations where each person has suffered a different amount of loss. A recent attempt to combine this ancient procedure with modern privacy legislation highlights the importance of this requirement. In Lloyd against Google, a Mr. Lloyd wanted to bring a representative action against Google for allegedly misusing the data of millions of Apple iPhone users by tracking their internet use and using the data for Google's own commercial purposes. He sought to meet the high threshold for bringing a representative action under English law by claiming that everyone with an Apple iPhone had the same interest in a claim for loss of control of their data. So he said a uniform sum can be awarded to everyone in the class, and there's no need to inquire into or value their individual loss. And hence, he said, no impediment to him representing the whole class of Apple iPhone users. His claim was dismissed at an early stage by the Supreme Court, which found that the privacy legislation did in fact require an individualized assessment of each person's loss. So it was not possible to quantify loss at the group level. So not every big claim strikes the court as being a good idea. The second mechanism is the most claimant-friendly of the 3, but is limited to one small area of the law. Collective proceedings in competition or antitrust law are based on a complex legislative scheme which provides for the relevant tribunal to certify the person who wants to represent the class as being an appropriate person to take on that role. The procedure has radically altered the established common law principle on which claims for compensation is based, because it removes by statute this requirement for the court to have to assess the individual loss of each claimant. If the collective action succeeds, then an aggregate amount of compensation, a lump sum, will be awarded to the representative on behalf of the class as a whole. And the arrangements under which the representative will then share it out amongst the members of the court have to be approved up front and are then supervised by the tribunal. The third mechanism was introduced in 2000 following Lord Wolfe's highly influential report entitled Access to Justice. He concluded that the existing procedural rules in England and Wales were inadequate for the complexities of multiple claims. The result was the introduction of group litigation orders. A group of people with claims raising common or related issues of fact or law can apply to the court for a group litigation order, providing for their individual claims to be managed together. Group litigation orders have proved popular and are an increasingly used mechanism for achieving access to justice. There have been 123 to date. One early example was the group action against the Royal Bank of Scotland arising out of the 2008 financial crisis. Some 9,000 shareholders brought a group claim arguing that the bank's directors had made misleading statements about the bank's financial health to promote a rights issue. The claimants included big institutional investors such as pension funds, but also small individual investors with just a few shares each, and they achieved a significant settlement. Reflecting on the case, one of the senior lawyers in the firm which represented the claimants perceptively observed that litigation develops in parallel with society. He said, "Go back to the 1950s, even the 1970s, and people wouldn't have dreamt of questioning the advice of their lawyers or doctors. Now, as a society, we've become much more aware of our rights, and that feeds into the legal system. If someone doesn't like the way they've been treated, they will much more readily seek the court's assistance in enforcing what they regard as their rights." The availability of group actions in my jurisdiction helps support England's reputation as a centre of excellence for international dispute resolution, and it can be a powerful way of ensuring access to justice, particularly in environmental cases. Let me give two recent examples. The first is the claims brought by a group of 1,800 Zambian citizens who live near the Nchanga copper mine. They alleged that the negligent discharge of toxic materials from the mine had damaged their health and livestock. What's that got to do with the English courts, you may well ask? Well, the parent company of the company which owned the copper mine was incorporated and domiciled in the UK. So the claimants wanted to bring their claim against that company, together with the subsidiaries more closely involved with operating in the mine, and they wanted to bring that claim in the English courts. And this raised a preliminary issue as to whether they should be allowed to pursue their claim in England. The issue went up to the Supreme Court in London in 2019. The court recognised that, considering where the alleged wrongful acts occurred and the location of the witnesses and the evidence, Zambia would ordinarily be the natural forum for the litigation. However, there was a real risk that the claimants would not obtain access to justice in Zambia. The claimants were described as at the poorer end of the poverty scale in one of the poorest countries of the world. They were dependent on the local watercourses as their only source of water for drinking, watering their livestock, and irrigating their crops. And it was those watercourses that they alleged had been polluted. Their ability to bring the claim at all depended on their being able to obtain the kind of group litigation order that the English High Court could make. At the moment, a similar claim is about to be heard next term by the High Court, arising out of the collapse of the Mariana Dam in southeast Brazil on the 5th of November 2015, Brazil's worst environmental disaster. It caused damage to the River Doce system over its entire course to the sea, some 400 miles away from the dam. There are over 200,000 claimants in the group litigation, including members of indigenous communities in Brazil, for whom the river plays a unique role in their spiritual traditions. The Court of Appeal upheld the making of a group litigation order in that case for the case to proceed in England. The court referred to the particular branch of the High Court dealing with the case as being well known for its ability robustly and actively to case manage complex litigation, including group litigation. The court guide published to help litigants emphasizes the importance of identifying the real issues, setting a realistic timetable, getting proper disclosure of documents from the defendant, managing costs, and encouraging the parties to cooperate. The court must always, of course, bear in mind what we refer to as the overriding objective of the court's procedural rules. That is literally Rule 1.1 of the Civil Procedural Rules, and is the objective of enabling the court to deal with cases justly and at proportionate cost. Another recent procedural innovation is the test case scheme, geared particularly towards issues raised in the financial markets. The scheme sets up a process whereby the sectoral regulator, the Financial Conduct Authority, can start proceedings asking the court to resolve an important point of law without the need for there to be any particular dispute between the parties actually before the court. This scheme was recently used to great effect to determine whether businesses could claim on their insurance policies when their businesses were closed because of the coronavirus pandemic. When lockdown was imposed across the United Kingdom in response to the pandemic, many shops and businesses which had to close looked at their insurance policies and saw that they were covered for business interruption resulting from infectious disease. Thousands of claims were filed under such policies by businesses suffering heavy financial loss. But many of the insurers rejected the claims and refused to pay, saying that the wording of the particular clause in the policy did not cover this particular situation. For example, some of the clauses in the insurance policies said that losses for business interruption are covered if the interruption results from the occurrence of a disease like COVID within a specified distance of the insured premises, say 25 miles. But, said the insurer, even if the business owner making the claim can show that someone within a 25-mile radius of their shop did have COVID, you couldn't say that it was that person's illness that caused the lockdown and hence the closure of the business. So the insurers said the loss was only covered by the insurance policy if the shop owner could show that it was because of the illness of the person within 25 miles that the business was interrupted. Well, the Financial Conduct Authority brought the proceedings for the benefit of policyholders, but without any particular policyholder having to be a party to the case at all. The approach taken was to consider a representative sample of standard form business interruption policies in the light of agreed and assumed facts. It was estimated that, in addition to the particular policies chosen for the test case, some 700 types of policies across over 60 different insurers and some 370,000 policyholders were potentially affected by the outcome of the litigation. The proceedings were started on the 9th of June 2020. The trial took place online over 8 days, just over a month later in mid-July 2020. A judgment from the High Court running to 580 paragraphs was handed down about a month and a half after that, on the 15th of September 2020. The case was appealed straight to the Supreme Court, bypassing the Court of Appeal, and was heard in November 2020, and judgment was handed down on the 15th of January 2021, a few days short of a year after the World Health Organization declared that COVID was an international pandemic. By the way, the Supreme Court held that as long as the business could show that there was one COVID sufferer within the 25-mile radius, they could claim on their insurance. The Supreme Court held that the lockdown, the national lockdown, was caused equally by every person's illness, and so there was the necessary causal link between that particular ill person and the closure of that particular business. Now, this was not a case where money to fight it was in short supply. When the case came to the Supreme Court, there were 9 parties, the insurers and the Financial Conduct Authority, a total of 31 barristers instructed to appear, of whom 13 were Queen's Counsel. But still, I'm sure that none of those little businesses would really have had the courage to take on the might of the insurance industry if the test case scheme had not enabled them to have the interpretation of their contracts dealt with so quickly and at the highest level. Let me now turn to how the digitization of dispute resolution procedures can help people gain access to justice. So here I'm not talking about the situation where there are thousands of similar small claims arising from the same unlawful act, but where a single claim arises out of a particular road accident or a faulty item bought in a shop or bad workmanship by a builder or other service provider. So let me take road accidents as an example. One of the most difficult challenges for any justice system is how to resolve the vast number of claims, each of which is for a few £1,000s brought by people who are injured in a minor road accident. These people undoubtedly have a claim, and most countries insist that every motorist is insured to cover paying compensation to someone who is injured by the negligent driving of the assured. Usually, there's not much scope for argument about who is to blame. But still, it's important to set up a system whereby the compensation due for the pain suffered and for any loss of earnings if the claimant had to be off work can be claimed. And it's important to do this without the claimant having to incur legal fees that will quickly eat away at the value of any compensation they're likely to be awarded. The English court system has tackled this by setting up a specially designed online platform where any accident claimant can apply quickly and efficiently. The would-be claimant enters the necessary details online, the date and time of the accident, information about themselves and the injuries they've suffered and any financial loss they've incurred. At the scene of the accident, they will have got the details of the other driver and as to who he's insured with. And so the online platform, if they enter that information, then automatically notifies the defendant's insurer. The platform guides the parties as to how to decide whether the other driver was indeed liable. And once liability is agreed, it guides them through the process of sorting out the value of the claim. It explains, for example, how to obtain and upload a medical report and gives guidance as to the appropriate value, the sum in money, for compensation for the particular injury suffered. The online platform for road accident cases has proved a great success, and in the vast majority of cases, the parties will quickly reach agreement on the amount to be paid without the claim ever having to go before a judge. The success of that platform, which was specific to road accident claims, has been matched by a broader online process, the online civil money claims service, which is available more generally to bring claims which are not for injuries, but for small amounts of money, for breach of contract, for example. The limit when the service was introduced was £10,000, about 46,500 shekels. It's specifically designed to be usable by litigants who do not have legal representation, but it was recently extended to allow claims which are brought by legal representatives up to a value of £25,000, about 116,000 shekels. The platform is accessed through the OCMC website and allows submissions of claims and responses online. On average, settlement is reached 24 days from the day the claim is issued. If you want to see how it works, I recommend that you search online for Small Money Claims UK and then go to the gov.uk website. Click on Make a Money Claim, and the website will guide you through a series of questions to check whether your claim is eligible. And if it is, the website will invite you to set up an account, and away you go. According to the government fact sheet published in February this year, the online civil money claims service has issued more than 470,000 claims from clients who are not legally represented since it was introduced in March 2018. It has achieved an average user satisfaction rating of 95% for claimants, and interestingly, 66% for defendants using the service. I wonder how many law firms could boast of similar statistics. The recent legislation, the Judicial Review and Courts Act 2022, provides for a special rulemaking body to devise online procedure rules. And this has the ambitious aim of connecting up many existing bodies, including charities, online mediation services, and arbitration portals, as well as the courts, to provide a one-stop shop for litigants. And at the UK Supreme Court, we are currently in the middle of our own modernisation programme. This autumn, we hope to launch an online case management system known as the portal. Rather than parties filing written applications, the portal will guide litigants again through a series of questions and allow them to manage their case online. All the language used and the digital forms on the portal have been designed to be intuitive and accessible and have been tested with various user groups. Let me now turn briefly to another aspect of access to justice, which is the right to have your case heard by an impartial and expert tribunal. Other colleagues who have had the privilege of giving this lecture in the past have talked about the independence and integrity of the judiciary and the importance of those for the rule of law. And this is, of course, a key element of access to justice. I'm going to talk about something different, which is the expansion of the tribunal service in the UK. The tribunal service operates alongside the court service. Each tribunal is set up by statute as the exclusive forum to hear a particular kind of appeal, usually against a particular kind of decision taken by a government official. And tribunals have two key features. First, they only deal with one particular area of the law. So there, for example, there is a tribunal for appeals brought by people whose claim to a social security benefit payment has been refused. There's the mental health tribunal, which hears appeals about whether a person who has been compulsorily detained in a mental hospital has recovered sufficiently to justify being released back into the community. And there's an immigration tribunal, which hears appeals from people who have been refused asylum or leave to remain in the United Kingdom. The second key feature is that a tribunal will often include on the panel a judge or adjudicator who is not legally qualified, but has a different relevant qualification or experience that they bring to the adjudication process. And this is particularly important in legal areas where there are likely to be a large number of litigants without legal representation. All these people would struggle to instruct and pay a lawyer to act for them, so it helps them gain access to justice if the burden of explaining the law or other aspects of the case is largely taken off their shoulders because the judges on the panel are people who specialize in that kind of law or are experts in another discipline. If I can draw on my own experience, my first judicial role was as a judge on a tribunal which deals mainly with antitrust and complex regulatory matters. In each case, I sat on a panel with two others, some of whom were not legally qualified. Instead, they were professors of economics or people who had spent many years working as company executives in the retail sector or in the telecommunications sector, or had accountancy qualifications. I also at one time sat on the environmental tribunal, which puts together panels to deal with particular sets of appeals. The ones I sat on, the success of a challenge to the particular decision by the Department of Environment turned on having someone on the panel who could look at a map and work out which way rainwater would flow down the features that were shown on the map. So I sat on those appeals together with a qualified hydrologist who had that expertise. Other tribunals may sit with a lawyer and a doctor to hear appeals in the mental health tribunal, or a qualified surveyor, expert in valuing buildings or land. But access to justice is not just about small claims, and even someone with a large claim may struggle to find the money for a lawyer and might be put off asserting their right for fear of losing and having to pay the costs of their opponent. In our system, the general rule is that the party who loses the case has to pay the legal costs of the party who wins. And this creates a large financial risk for anyone thinking of bringing a claim, even if the claim is for quite a lot of money. Nowadays, I think most people would recognize that if you want access to justice for a complicated case, you would have a better chance of getting the result you want if you can have a qualified lawyer in your corner. So how do you ensure that access to justice is available to everyone, not just the very rich? In England, we used to have a generous system of legal aid in civil litigation in addition to criminal trials. This system was set up at the same time as the other core parts of our welfare state, such as the National Health Service. In the days of legal aid, you could instruct a solicitor and barrister, and they would send their invoice to the government, which would pay it, although the government fixed the rates at an hourly rate much lower than private clients would pay. But that system has largely been abolished in England and Wales, except for limited eligible categories of legal work. But the desire of the state to save money by removing legal aid has been accompanied by a complete turnaround in attitude towards two things. The first is attitudes to what arrangements are appropriate and ethical for lawyers to enter into with their clients about the amount and the payment of their fees. And the second change is to whether it's appropriate for some third person who is not actually either defendant or the claimant, whether they can provide funding for the lawyers to fight the case, usually in return for a share of any compensation that the claimant wins at the end of the trial. And the common model now is to combine those two. Until quite recently, such arrangements amounted to committing a criminal offence under English law. So it was illegal, criminally liable, for a lawyer to agree with his or her client that the payment of their fees was dependent on winning the case. And it was certainly illegal to agree that the amount of the fee would be calculated as a share of any damages received from the other side if the lawyer's work was successful. The ancient criminal offences of champerty and maintenance date back to the 13th century. Champerty, an agreement under which a third person would be paid a share of the compensation received, was regarded as particularly pernicious. It was thought that the purchase of a share in litigation presented an obvious temptation to the suborning of justices and witnesses and the exploitation of worthless claims which the defendant lacked the resources or the influence to withstand. Those criminal offences survived long after the medieval rationale had fallen away, but it was not until the late 1960s that litigation funding was decriminalised. But even then, the common law continued to consider such agreements as contrary to public policy and therefore still unenforceable, even though not now a criminal offence. But a combination of liberalising legislation and a series of important court decisions has dramatically changed the landscape. Now, these kind of arrangements are commonplace. Now, a typical conditional fee agreement between a client and their lawyer will contain 4 essential elements. First, the lawyer will agree that she will only be paid her fees if the client wins. If the case is lost, the lawyer will have worked for nothing. Secondly, she will usually agree to wait until the end of the case before collecting any fees rather than being paid as she goes along. Thirdly, to compensate her for the risk, if the lawyer wins, she gets not only her fees on the hourly basis, but also an uplift, an extra amount which is usually expressed as a percentage of the fees earned as a success fee. So that if the lawyer wins, they will get 125% of the cumulative hourly rate fees. Fourthly, the client will take out an insurance policy because if he loses, although he will not have to pay his own lawyer because the condition for the payment of her fees won't have been met, he is likely to be ordered to pay the costs of the other side. So he takes out an insurance policy to cover that risk. As to third-party funders, global businesses have sprung up which treat large-scale litigation claims brought in our courts as an investment vehicle, gathering contributions in from a wide range of sources to finance the lawyers and the expert witnesses in exchange for a share of any winnings, which are then distributed amongst the investors to give them a profit on the money they put in, just like interest on a loan or a dividend on shares. So in the third-party funder, the person taking the risk of losing their money are not the lawyers, because they will get paid as normal. It's the third-party funder who puts up the funds for the lawyer's fees, but will lose all that money if the claim is lost. Many judges have mixed feelings about these developments. On the one hand, there is no doubt that this funding has enabled many thousands of litigants to have access to justice that they certainly would not have had if they had had to find the money to pay lawyers from the start of the case, and if they had had to take the risk of paying the opposing party's fees if they lost. And supporters of the arrangement say that lawyers and third-party funders will only take on a case if they think it's got merit. Otherwise, they take a very strong risk of having worked for nothing or having lost all their investment. So the system, they say, should weed out bad claims because no one will want to fund those or risk working on them for nothing. The kinds of disputes that have benefited from this kind of third-party funding are hugely varied. They range from the Spanish fishermen challenging the ban imposed by the UK government to stop them from fishing in UK seas, to the ex-wife of a very wealthy Russian businessman trying to enforce her divorce award of over £430 million against his yacht and works of art, to the recent case brought by Mr. Bates against the Post Office arising from the Horizon computer systems scandal. On the other hand, some lawyers feel uncomfortable at the idea that a piece of litigation can be regarded in the same way as a hedge fund or a portfolio of stocks and shares for use by people looking to invest their money for a profit. And they also say that a defendant faced with a claimant who is not personally taking any risk with their own money may well agree to a compromise by paying damages, even if the claim has little merit, rather than face the prospect of years of litigation. To mitigate these potential problems, the freeing up of methods of litigation funding has been controlled by regulation, both government regulation and by codes of conduct. For third-party funders, there's now an organisation called the Association of Litigation Funders of England and Wales, which has published a code of conduct for third-party funders as to what they should and should not include in their contracts. For example, it requires that the funder ensures that the client who's going to be a party to the litigation has received independent advice before entering into the agreement. And the funder must also promise not to try and influence or control in any way how the lawyers conduct the case. Conditional fee agreements between clients and their lawyers are closely regulated by the state to ensure that litigants are not exploited. So there are regulations in place that specify that any arrangement must be in writing, must state the percentage amount of the success fee uplift, and that the success fee must not be more than 100% of the fees actually earned. The importance for the lawyer of making sure your agreement is drafted to comply with the regulations was dramatically illustrated by a recent case in which an international law firm racked up $3 million in legal fees representing a client in a major arbitration. Their client won an arbitral award measured in billions of dollars, and the lawyers asked for their fees. Far from being grateful for all the hard work the lawyers had put in on their behalf, the client refused to pay. Unfortunately for the law firm, their terms of engagement did not expressly state the success fee percentage, and the formula set out in the agreement would, applied to the facts of the case, result in a success fee in excess of 100%. The agreement was therefore completely unenforceable. The lawyers were not only prevented from claiming more outstanding fees, but to add insult to injury, the court said that they had to pay back to the client the fees that the client had already paid. The public policy was clear, the court said, and though it could operate harshly in some cases, it was not difficult for a law firm to draft their agreement so as to comply with the regulations, and it should be something the law firm thinks about carefully before signing up a particular client. Alongside these fundamental changes to how lawyers can be paid, there's also been a huge increase in the amount of pro bono work. And this is one of the things I was discussing with one of the seminars that I held earlier this morning, where the lawyers agree to work for nothing as a public service in the clinics that I was being told about. I'd like to mention briefly one commendable initiative from which I certainly benefited when I was a High Court judge. There's a scheme set up in the Chancery Division of the High Court which provides on-the-day advice and representation to litigants who would otherwise be unrepresented when bringing or responding to an urgent application. Barrister volunteers make themselves available for the day. They sit outside court and they help whoever comes through the door to attend the judge who is dealing with a list of cases, each of which is only going to last for a short time. The Chancery Court scheme is a four-way win. First, it gives junior advocates a chance to get on their feet and argue a case in a senior court. This is especially valuable because this court deals with areas of the law where there are not many small cases, so junior advocates often don't get the chance actually to stand up and address the court. Secondly, it gives the litigant the chance to get some free legal advice and someone to help focus the case on the best arguments they have. Thirdly, the judge is relieved of trying and extract the basic facts from a nervous litigant who's probably standing before a judge for the first time. And fourthly, the court system wins because the advocate will often sift out hopeless cases and speed up the good ones, making the process more efficient. It would not be right, however, to suggest that these methods of mitigating the impact of the withdrawal of legal aid have entirely plugged the gap. The provision of legal aid in the areas where it still exists is a bit patchy across the country, according to the Law Society. And the National Audit Office, which is an independent body which investigates whether public spending is providing good value, has recently reported that yes, a lot of money has been saved in not providing legal aid, and that is recorded by the government, but they're not so efficient at recording whether actually the expenses are just moved into a different area. So cases may take up more court time and resource where the judge has to do quite a lot of the work that would have been done by the lawyers. Contrary to public perception, lawyers working together with judges and court staff tend to be good at resolving disputes efficiently. Finally, I want to focus on why providing access to justice matters, not just to the litigants themselves, but to the development of the law. Anyone who wants to understand what access to justice is and why it is important in society would be well advised to read the judgment of Lord Reed, now the President of the Supreme Court, in the landmark ruling about the introduction of fees for claimants who want to bring a case in the Employment Tribunal. Employment tribunals are the first court for claims by people, for example, saying they've been unfairly dismissed from their work, or they've been unlawfully discriminated against in their work. And until recently, claims could be brought without the claimant having to pay a fee when lodging their claim. The government then brought in a new regime of fees for lodging such claims. The challenge to the legality of the fees was brought by a trade union which represents some of the lowest paid workers in our society, and the fees imposed would in many cases be much higher than the value of the case. The government's justification for imposing fees where none had been imposed before was this: it costs money to run the tribunal service, to pay the judges, and to provide the premises. If there are no fees for bringing the claim, then all that expense is being paid for by the taxpayers generally. But, the government said, the only people who benefit from the system are the few people who use it. The government's case, therefore, was based on the assumption that there were what it called, quote, no positive externalities for society from the consumption of tribunal services by litigants. In other words, the government said, the use of employment tribunals, or presumably any court, doesn't lead to any gain to society beyond the gains that are enjoyed by the consumers who use the tribunals and presumably the people who get paid to run them. The Supreme Court disagreed. Lord Reed said, Access to the courts is not of value only to the particular individuals involved. The administration of justice is not merely a public service like any others, and courts and tribunals are not just providers of services to users who appear before them. There are wider benefits to society. The most obvious one is that cases establish a general principle of law, which then governs how the law applies for the future. Lord Reed said, "Every day in the courts and tribunals of this country, the names of people who brought cases in the past live on as shorthand for the legal rules and principles which their cases established." Lord Reed pointed out in his judgment that the written submissions lodged by the government prior to the hearing of this very appeal cited over 60 cases, each of which bore the name of the individual involved, and each of which was relied on as establishing a legal proposition. The government's own use of these materials refuted the idea that taxpayers derive no benefit from the cases brought by other people. Further, the cases decided by the courts also form the basis of advice given to those whose cases are now before the courts, or who need to be advised on the basis of which their claim might be settled, or that their claim is hopeless. And there's also a wider benefit to society and businesses and individuals knowing that they can enforce their legal rights if they have to, and that they face a real risk of being sued if they infringe someone else's rights. The ultimate threat of court underpins, Lord Reed said, everyday economic and social relations. In other words, what makes people in general stick to their contracts and take care not to act negligently is the knowledge that a person harmed by their conduct will have access to a court to enforce their rights. The cases Lord Reed cited in judgment include perhaps the most famous case in English law that every law student learns in their first week of study, Donahue and Stevenson, the case about the claimant who got ill from a decomposed snail in a bottle of ginger beer. And one of the great benefits to society of access to justice, particularly from small cases, is that it is from apparently trivial cases that great legal principles can emerge, principles that are then passed down through the generations and from which we all benefit. So let me close with two such cases separated by over 300 years. The first relates to an all too familiar modern experience, a cancelled flight. A case came before the Supreme Court earlier this year concerning Mr. and Mrs. Lipton's claim for £220 compensation after their flight from Milan to London was cancelled. The airline argued that since the cancellation was caused by the pilot falling ill, they could rely on the defence of extraordinary circumstances provided by the relevant European Union law. Hardly, you might think, the stuff from which grand decisions are made. As it turned out, the case more than justified the Supreme Court's attention. First, tens of thousands of claims are made under this legislation every year in the UK. So precisely because the amounts of compensation are small, it's crucial that the rules are stated clearly. But secondly, between the date of the cancelled flight and the date of the court hearing, the United Kingdom left the European Union. The case therefore raises the important question as to how, under the legislation which brought about Brexit, causes of action which accrue before Brexit should be approached in the courts hearing the case now. And that same question will arise in respect of all former EU law and urgently requires an answer. So again, the significance of the court's decision will extend far beyond the immediate parties to the case. Looking further back, the point is equally well illustrated by the old case of Armory and Delamere. The case was heard by Sir John Pratt, who was Chief Justice of England between 1718 and 1725. The judgment dates back to 1722 and is one of my favourite cases. This is how it appears in the law report. It's commendably short. It's just this little passage here, the judgment from 1722. So I can read out the relevant parts in full. By way of background, let me say that in the 18th century and through much of the 19th century, there were a lot of chimney sweeps at work in London, think Bert in Mary Poppins. And it was customary for chimney sweeps to employ little boys to climb up the inside of the chimney and push down the soot, although I'm sure that Bert in Mary Poppins never did anything so cruel. So this is what the report said. The plaintiff, being a chimney sweeper's boy, found a jewel and carried it to the defendant's shop, who was a goldsmith, to know what it was, and delivered it into the hands of the apprentice, who, under pretense of weighing it, took out the stones, and calling to the master to let him know it came to 3 halfpence, a very small amount of money, the master offered the boy the money, who refused to take it and insisted to have the thing again, whereupon the apprentice delivered him back the socket without the stones. So now the little chimney sweep brings an action in trover, which was an ancient action that you could bring to recover goods that somebody had taken from you. So one can picture the scene of the ragged little sweep appearing in the grand surroundings of the Chief Justice's court. But because he could achieve access to justice, we have this case, which for many years has stood for 3 important legal propositions. The first arises from the fact that it wasn't the goldsmith himself who took the jewel, but his apprentice, who was behind the shop counter when the sweep went in. So the case is authority for the fact that the goldsmith could be legally liable for the conduct of his employee, an important point which is certainly carried through to today. The second principle is that the goldsmith argued that because the sweep's boy could not prove he was the legal owner of the jewel, he couldn't bring the claim. That didn't matter, the Chief Justice said. As long as the little sweep has a better title to the jewel than a goldsmith has, which he clearly had, he can still bring the claim in trover. The third point is one for which the case is still often cited today. The goldsmith's other line of defense was because the little sweep could not produce the jewel to the court, he could not prove whether it was a high-class, valuable jewel or not, whether it was, they say in the report, a jewel of the finest water or the greatest clarity. And so he couldn't prove the amount of compensation that he was entitled to. So the law report records how the Chief Justice dealt with that. As to the value of the jewel, several jewelers were questioned to prove what a jewel of the finest water that would fit in the socket would be worth. And the Chief Justice directed the jury that unless the defendant did produce the jewel and show it not to be of the finest water, they should presume the strongest against him and make the value of the best jewel the measure of their damages, which they accordingly did. So the case establishes that where a defendant has put it out of the claimant's power to prove the value of their loss, the judge must presume that it has the highest possible value. I'm not the only person to find this short and intriguing law report leaves so much unsaid. How was it that the Chief Justice came to preside over this little claim brought by the little sweep's boy? The American novelist A.M. Watson published a novel in 2017, Infants of the Brush, a chimney sweep story, which is a fictionalized account of the life of this little claimant. A lot has changed since Lionel Cohen sat as a judge in the House of Lords, which was then our Supreme Court in the 1950s. On the whole, I'd say things have changed for the better. Certain values, though, have remained broadly constant. The fundamentals of what we mean by access to justice have remained the same: ready and affordable mechanisms of redress through which individuals can enforce their legal rights. What has changed is the society and the economy in which the goal is now pursued. But just as many of the challenges I've surveyed this afternoon are distinctly modern, so too are the solutions. Many of the claims I've described would have been unthinkable 70 years ago. So would the idea of making and resolving a claim entirely through the computer. The challenge we face is making the most of these new technologies and practices without losing sight of what worked in the past. Like Moses and Jethro, we must innovate without impairing the quality of justice being dispensed. but it is, I hope, possible for us simultaneously to modernize our justice system and to keep hold of the hard-won accomplishments of our ancestors. It is, I would suggest, that blend of creativity and conservatism which will be the best way of achieving access to justice in the modern state. Thank you.